Good morning, everyone. My name is Suzanne Templin, and I coordinate the webinars for Hausmann Johnson Insurance. I would like to welcome you to today's webinar titled Investigating Complex Workers' Compensation Claims. Today's webinar will run about 45 minutes. We currently have all attendees on mute, and after the webinar, we will have a question and answer session. If you have a question during the webinar, feel free to type it into the chat feature, and Peg will address it during the Q&A portion. After the webinar is over, there will be a short survey we are hoping you can fill out for us. A note that this webinar has been certified for continuing education credits by the Society for Human Resources Management and the Human Resources Certification Institute. Details on those credits will be provided to you at the conclusion of the webinar. Also, please be aware that this webinar is being recorded and will be available for review on the webinar archives of our website. If you do not want to participate in a recorded webinar, you may want to close this application at this time. I will be emailing everyone who signed up for this webinar with a copy of the presentation and a link to the recording. You can also find today's presentation in the handout section of the GoToWebinar application. I would now like to introduce you to our presenter for today's webinar, Peg Kramer. Peg has over 20 years of experience in the claims field, which she leverages to be a champion for clients when they are faced with difficult situations. Peg believes that Wisconsin has the fairest and most equitable workers' compensation program in the nation for both the employee and the employer. She prides herself in educating clients on what their options are under the program and how to prevent accidents, work with injured workers, and save money doing it. She graduated from the University of Wisconsin-Platteville with bachelor's degrees in criminal justice and psychology, and we are so grateful to have her share her expertise with us on this often misunderstood topic today. Welcome, Peg.
Thank you, Suzanne, and welcome everyone, and good morning to all of you listening in. I'm very glad to be speaking with you this morning about investigating complex workers' compensation claims. I'm hopeful that the information discussed here today will prepare and educate you when a serious injury occurs at your business. As Suzanne had mentioned, I have over 20 years experience, and the majority of that comes working from the insurance carrier side of the business. So I'm hoping that you can go away with one or two tidbits to be prepared if a serious injury would occur at your place of business. So let's begin. We're going to talk today about how to create a successful outcome following serious workers' compensation injuries and resulting investigation from your insurance carrier. So where do we begin? One of the most important, I think, top 3 items that you can do as a business person is reporting these claims timely to your insurance carrier. I cannot stress enough how time is of the essence in these situations. You should be reporting all claims within 24 hours from the time of the incident to your insurance carrier. If this is a catastrophic claim or serious injury where people are taken by ambulance, I would strongly suggest that you call these claims into your insurance carrier directly. If all else fails and you are very stressed out and not sure what to do, please call us immediately at Hausmann Johnson for assistance, and we'll be happy to help you out in these stressful situations. So what types of claims are we talking about where a complete, detailed investigation is required? Let's walk through some of these, and I would like to give some examples. If you have questions, we'll probably take a break in the middle of the webinar to tackle some of these, and once again at the end. If you hire independent contractors, this is happening more frequently, as I see in our customers. You can be held responsible for their injuries if they do not have current workers' compensation coverage. Make sure when you hire independent contractors that they present a current certificate of workers' compensation insurance to you. In Wisconsin, there is a 9-point criteria for individuals to be classified as an independent contractor. If they do not meet all 9 of these criteria, they can be considered your employee. So I think that is a very important piece that you should be aware of when hiring independent contractors. Amputation injuries, and I think that goes without saying. Any amputation injuries that you have should be reported immediately, as well as to the Workers' Compensation Division, and check with your insurance carrier as they may do this for you. Injuries involving machinery. Anytime a machine is involved with a serious injury, I really strongly encourage you to talk with your insurance carrier immediately, as there may be something wrong with the machine, and that does need investigation, whether it's by a safety engineer hired by the insurance carrier or manufacturing reps coming onto the site. But those types of things should be checked out, and we'll talk a little bit later about what to do with pieces of broken machinery themselves. Any questionable injuries that you have where the facts do not line up, when the injured worker comes and talks to you and they're not sure when this happened or if it's even work-related, those types of claims should be sent to the insurance carrier for them to do a complete investigation to determine causation. And when I say causation, the question is, what is the cause of this injury? Is it work or not work-related? Catastrophic injuries, we're talking about fatalities, or injuries where several of your people may be at a job site and are exposed to carbon monoxide. Automobile accidents where several people are in the car at one time. This would be something you would want to call in immediately. Serious surgery that seems to be unrelated to the injuries. Quite often we do see where individuals that you have hired bring along pre-existing conditions, and they may have a minor incident that occurs on the job and then require surgery. It is very important for the insurance carrier to determine if surgery is going to be required from a minor incident, or does this relate back to their pre-existing conditions. And I think that's probably one of the most common topics in all of these examples that we do see. Serious surgical claims where we're talking fusions, types of surgeries where I'm thinking back to 5 or 6 years ago when artificial discs first came out. That was not approved here to do in the United States. However, surgeons were doing them. So make sure that if your injured employees are headed for that, they give you a heads up, hey, I'm headed for this type of surgery. They're going to do 4 procedures on my shoulder. I truly think that that would be a call-in claim as well. Subrogation claims, and when I talk about that, it's seeking a third party that's responsible for your employee's injury to recoup monies that have been paid out on your behalf to your injured worker. If a third party is responsible, such as an auto accident, a machine that is malfunctive, those claims, the insurance carriers definitely will want to get on board if they have an opportunity to pursue monies paid out on your behalf. And then last, occupational injuries. And I think about drywallers when I talk about occupational injuries. Individuals that have worked in the same profession for many years, and when I think of drywallers carrying the big sheets of drywall above their head and doing overhead work for 20 or 30 years, or carpet layers who have been on their knees, and their knees are shot, shoulders are shot, and those type of claims should be investigated as well. When reporting to the insurance carrier, please keep your first report or employer's first report of injury, which is a state form, keep them very generic and factual. If you have detailed personal information about the injured worker, that should be kept separately and sent a cover letter, or pick up the phone and call your adjuster if you have a relationship with them. When I was on the insurance carrier side, several of our large accounts would call ahead and talk to us about past issues or past history of the injured worker, which gave us a good head start, and we knew immediately how to triage that claim and what to look for. But please keep this separate because this information is discoverable, meaning someone else has the potential to look at this information. So keep them short and factual, and your adjuster will be talking to you about information you send in or on the phone when they make their first contact to you. You know your people intimately, and the insurance company does not. So the more you tell them, I think the smoother the investigation will go. Also, know what to expect from your insurance carrier. It's a two-way street. They can only do the best job for you with the information that you give them. They don't know what they don't know. So once again, you know your people, you know their personnel records, you know their attendance records, you know if they're having trouble at home, you know these people. They do not. In the claims process, it kind of is sometimes forgotten by the employer, but you have the injured worker, you have yourself in the business, and then you have the insurance carrier. And it is paramount for you to maintain constant communication with that injured worker. I cannot tell you how many times we have heard over the years, and it may sound very sophomoric, but we hear injured workers say, you know, I haven't heard from Joan in HR or the plant nurse. I don't think they care about me. I have updated information. I want, to reach out to them, and we encourage them to reach out to you, but you should be reaching out to them as well to, encourage attendance at medical appointments, attendance to the medical treatment plan, and just overall generally, letting them know what's been going on and show concern for them. You do have to keep a neutral role, however, because you're still the employer, they're still your employee. So please try to keep a neutral role as possible. Allow the insurance company to be the bad person in this three-way relationship if need be. But you also need to let them investigate and communicate with your employee to do the job that you are paying them to do. Studies show, and in my 20 years experience, also verify that employers who show interest in injured workers after an incident do see a decrease in lost time. People are getting back to work sooner than later, I should say. So how do we get the best results working with your insurance carrier? Starting out, it does behoove you to have a relationship with your insurance carrier so they get to know you and you get to know them, and they're aware of your culture. Some of you may have assigned claim representatives that you work with right now, and it does behoove you before a serious accident occurs to have that relationship in place. I also think it doesn't hurt you to confirm when you have a serious claim that you're just verifying with them that a complete investigation will be done to include a statement from the injured worker, any witnesses involved, and the injured employee's supervisor. So it's good to know what they plan on doing, and hopefully that is in sync with what you are seeing as well. But time is of the essence because people forget things. I mean, do you know what you had for lunch yesterday and where you were at? People forget, and within 24 to 48 hours, sometimes recall isn't as good as it should be. And if other agencies are involved, make sure a full report is ordered and pictures are taken. And we'll talk about that a little bit later as well as to who these agencies may be. So in assisting the insurance company, you will want to have someone on site ready to assist the claims representative when they make an on-site inspection. This may be their own staff, which may be the person you have talked to on the claim. If they're a desk adjuster, they may send a field person out to meet with you, or they may hire an independent adjuster, depending where your location is at. Now, if OSHA calls because there's an amputation injury, fatality, and they want to come out immediately and inspect the site, I would strongly suggest that you contact your agent here at Hausmann Johnson to talk with talk with one of our two loss control representatives or the insurance carrier immediately. Remember, OSHA is a four-letter word, and when I think of OSHA, I think of fines and penalties, and you do not have to let them on site immediately. You do have to have some time to get the proper people aware, and I wouldn't go through an inspection alone. One thing is ultimately very, very important is do not alter, if machinery is involved, do not alter or throw any broken parts away that may have been involved in an accident. Everybody carries a cell phone nowadays. Make sure pictures are taken immediately after the scene. Don't clean anything up until photographs have been taken, whether it's by the claim rep or coworkers or the plant safety manager, to document exactly how the machine was when it was found after the accident. If you do have to remove items, put materials in a safe and locked environment, and have just one person in charge. You don't want to end up in a court of law and the lawyer asks you, well, who touched the damaged materials from the machine? You don't want to have to say, well, 7 different people at our plant touched the items, and you want to have a good chain of evidence. And when I say that, have one person involved so that you can just say, our plant manager was the one that removed the items, labeled them, and locked them away in a safe environment, so that you're not accused of sabotaging parts, or that parts were thrown away, and you're able to show that you did what you were supposed to do and not tamper with these items. So what type of documents will I need, and from whom? Who should be involved? Definitely personnel records, although some of your people have worked there for 20 or 30 years. We don't expect you to have 20 or 30 years of records available, but I'm sure that the carrier will want to get to know the person that they're dealing with. And 9 times out of 10, if you have a problem employee and they have a workers' compensation claim, don't think that it's going to go well. If they are a problem for you beforehand, they're going to be a problem now. You will also want, and this is very important, a job description, either written or a videotape. And this is for not only immediately for the insurance carrier, but down the road with the doctor's office when you're talking about returning people to work. And you would be able, or someone else, a nurse, would present this information to the doctor to see if the injured worker is able to go back to their regular job. You will also want to have manufacturer's information if equipment is involved. You want maintenance records of the machine that you do internally. Perhaps your own people do maintenance on machines, so you'll want their log records, and also manufacturing reps that come in and do inspections. They may keep a log stamped right on the machine itself, the dates they've been there, and keep a record with you. You may also try and ask them for their own records that they keep, and they may or may not give those to you. But if you know that they keep them, that could be subpoenaed down the road if need be. You also want time cards to verify that the injured worker was there the date that they are claiming they're injured. Don't be surprised when I tell you that we have had people claiming a specific date of incident and they haven't even been at work. So don't take things for granted. Make sure you dot all your I's and cross all your T's when a serious incident occurs. Also, any current information that involves either an ADA or FMLA claim that may be going on concurrently. You will definitely need wage information hourly and yearly to report to the Department of Workforce and Development. In Wisconsin, the Workers' Compensation Division keeps meticulous records of how much and how often and what type of benefits that the insurance carrier is paid to your injured worker. Specifically, this is what they're looking for, and they do need this on a timely basis, or you can be fined. They take, when your people are injured, they take the date of the accident and go back 52 calendar weeks, or as long as they have worked for you, to find out what that gross amount is, and then divide it by 52 weeks. They then measure that against the hourly wage rate to see which is bigger. Whatever amount is bigger is considered the average weekly wage, and 2/3 of that, it will be their temporary total disability rate. In Wisconsin, the maximum wage rate they are paying for 2016 is $936. Also, any disability slips from treating practitioners that are received or verbal information would be very important to have available. So we've kind of talked about everything else except the injured worker. And in work comp, that kind of takes care of itself. So if someone is injured, do not take them to the hospital yourself. If it's a serious injury, call 911. You have certified emergency medical technicians that are trained to help them and help them along the way if need be before they get to urgent care facilities or a medical facility. You never, ever want to let an injured employee drive themselves for medical treatment. No way, no how. A supervisor, family, or ambulance should be the form of transportation, and many times it usually ends up being a supervisor, but in the case of a serious incident, 911 is your best bet. If it is a supervisor themselves that is injured, they should you should have someone contact their family member to come and take them home if medical care is temporary. Excuse me. So who else would be involved with our injured worker? Before we get into this, I kind of wanted to make mention of other people that may be involved when an accident occurs. So we talked a little bit about the ambulance, and of course they do write a report. If the police are called, they will write a report. If the state patrol is involved, if a safety engineer is involved, I'm trying to think of all the different entities that may be involved where you would have a report available to you. And when ordering these reports, or when the insurance carrier orders these reports, they order a complete report. When you and I get in a car accident, we request a report. It may be a 5 or 6 page report. However, many times if the police are called or the ambulance, they will have an extended report that may include pictures, diagrams, information that you would want your insurance carrier to know. So make sure if you are requesting these reports from these other people involved, ask for the complete report. So let's talk about physically who else would be involved in this case other than yourself, the injured worker, and the insurance carrier. Most times, many insurance carriers have their own registered nurses who work for them and have a territory. Some have telephonic case nurse managers that are strictly in-house. But if it's a serious injury, you have the right to request that a nurse be assigned, and most insurance carriers will do this anyway. But I think it's good to have a field case nurse immediately when you're talking about several-day hospitalization for your injured worker. And who exactly are these people? Majority are registered nurses who specialize in occupational injuries. They usually have a background in orthopedic or neurosurgery care, sometimes in a trauma center, or they worked in a hospital setting or clinical setting and have dealt with these types of injuries. They are the eyes and ears for you and the insurance company. They also act as an advocate for you, for your employee in the healing and return to work process. And many times, they will call you immediately after a medical appointment to update you as to what's been going on, and they certainly will do that for the insurance carrier. Many of these nurses will attend medical appointments, and the doctor will sometimes let them in to the actual appointment. Sometimes they do not. So the claim is going, you've had an incident, and medical care is underway, and you think, gosh, this is going to cost a lot of money. The insurance carrier is going to raise my rates because, you know, this person's in a trauma center. They've been there for a week. They're going to have several surgeries. This is going to be a long-tail claim. How can I, as the business person, as the employer, mitigate this claim to where I feel in control or that I've done the most that I can do? Along with reporting timely, as the agency here, we talk to our clients about having a return-to-work program or a stay-at-work program, as it sometimes is referred to. This is finding temporary work for, I would say, if you can find 6 to 7 positions that would be on a temporary basis to be available to injured workers after they've been injured and seen by the doctor. Even a casual strain, most times the doctor will not release them to their pre-injury job and will have them under work restrictions for a couple of weeks. With a serious injury, the return to work may be right away, but it's going to be a long time before they're able to go back to their pre-injury job. And you don't want to make this into a full-time job. It has to be temporary work that they can do while they're in the healing process. And you may as well have them at work in the healing process versus sitting at home on the couch and watching the Oprah channel. So a field case nurse and claims representative can present this information to the treating practitioner of employment opportunities you as the employer and business owner have while the worker is healing, so that they're not receiving temporary total disability, they are back to work. And the benefit is, if you are able to offer regular hours and regular pay to your injured employee and bring them back within the temporary work restrictions that the physician is given, you'll save money by the insurance carrier not having to pay out weekly indemnity benefits to your worker. And remember, as I said, $936 is the max rate this year. So that can keep costs down, which would definitely reflect on any increase this claim will be causing to your premium. So one thing that is complicated and also nerve-wracking, and you will experience as the employer, is this claim, if it's questionable or a very serious injury fits one of the criteria that we've talked about before, how long is it going to take the insurance company to investigate this claim and make a decision as to whether or not it's work-related? The state of Wisconsin will give an insurance carrier 4 to 6 weeks to make a decision on a claim before bells and whistles go off with the Workers' Compensation Division. Remember, the claims representative are responsible for many claims, not just your own business, but they have to interview witnesses, they have to obtain medical records, current and prior, and if it's a prior, let's say they've broken a leg or they have a bad back and you knew in hiring them, or afterwards you find out they had prior back problems, you'll want to get all those prior medical records. And it is imperative that you're able to speak to the injured worker to get this information as soon as possible. Not when they're all medicated or, you know, still in the ICU ward. You have to give it appropriate time, but it is imperative that the insurance company gets any prior medical information, specifically if they've had prior medical treatment to the injured body part. The claim reps that are assigned also probably pay their own medical bills. They're paying weekly benefits to injured worker, and they're getting new mail constantly. It's nothing for them to get 40 to 60 pieces of new mail a day on their claims. And industry standards tell us that the claim reps have normally between 120 to 160 claims, and they really should have no more than 100 if they're traveling in their territory and making account calls. So these people are busy, and it's not that they're not taking your claim seriously. They just have a lot of work to do. If you do think that it's taking an extra long period of time or that you're getting pressure from the injured worker because they're not receiving a check, please reach out to us, and we're always more than happy to contact the insurance carrier and talk to them. We do have access to their website information as well, and probably may be able to give you the answer right away. But you do not want to pay for a claim that is not yours. If it's related to something else, then group health insurance kicks in, or perhaps the prior insurance carrier. We only want the insurance carrier to pay claims that you owe. So how can we help the insurance carrier investigate a claim? Any medical correspondence that you would receive from the injured worker or their physician should be labeled with their claim number assigned by the insurance carrier and sent in. Please do not send in any information without a claim number. It's going to go into a deep abyss and may never come out. Your employees are known to the insurance carriers. They know their names, but the claim number is what will suffice and get the question answered more quickly. You will also want to know that if your employees are given restrictions once they've been released to return to work, that they need to adhere to these restrictions 24 hours a day. It's not just, it doesn't just apply to the regular 8-hour workday. So if coworkers come in or somebody else comes in, you live in a small town, and you say, well, gosh, I thought John's work restrictions were, you know, sedentary work or no ladder climbing and no lifting over 20 pounds. Gosh, I saw him lifting his second-grade grandchild and carrying her around the yard, or I saw him up on the roof, laying shingles. That information should be noted and a statement signed by that person and the rehab nurse, or you can give this information to the physician to say, look, I know what the medical treatment is for John and Joan. They're not adhering to it on a 24-hour basis. Sometimes the physician will take that into account and may decrease the work restrictions or totally release them to return to work without restrictions. This can also backfire as well, because we've heard many physicians say, well, your employee has to live and have a normal life as well. But it goes to their character, and I think this information should be known. So at this time, before we walk through a claim together, I wanted to ask if you have any questions up to this point. I'd be happy to take some questions.
Please feel free to type your questions in, as everyone is on mute right now. We'll give you about a minute or so to do that. All right, so it looks like we did get a question from James. If a person comes back on light duty, do you have to pay them their normal rate?
Oh, that's a great question. No, you do not. If someone has a $20 an hour job and they're coming back to something that isn't worth $20, perhaps you decide to, for financial reasons or just it's a decision made at your place of business, and you decide to pay them $10 an hour. So you're going to offer them so many hours of work per week. You're going to pay them $10 an hour. At the end of every week, you will report that amount offered and amount what you paid to your insurance carrier, and then they will pay a percentage, not the full amount, but a percentage of the difference in the 2/3 work comp formula to your injured worker. The reason we ask our employers to pay regular wages is to possibly avoid the claim being a lost time claim. And when I say lost time, with serious injuries, you are probably going to pay some permanent partial disability. But if you can get that person back to work without paying any lost time, the claim will be reported to your regulatory agency as a medical-only claim, and you get a 70% monetary discount off of your medical claim. Meaning if an individual goes in and has $1,000 worth of medical care, that when it's time for the claims to be reported to your regulatory agency that calculates your premium, it's going to get reported only as $300. So it does behoove you to keep claims as medical only if you can. If you cannot, the second best way to mitigate, James, is to pay them a partial wage, and then the work comp carrier will pay them a percentage of the difference. But that's a great question, and it happens all the time.
We have another question from Sherry. While a claim is being investigated, should the employer be paying the individual as well? If so, where does the payment go when the claim determination is made?
Oh, that's another great question. And my answer to that would be no. You want to let the insurance carrier do their job, do their due diligence that's owed to you. You don't want to set a precedent, because this could go on for 8 weeks, and if they earn $2,000 a week, you paid out $1,600, you're not going to get $1,600 back from the insurance carrier. You're only going to get $936 a week. So if employees know that, it wouldn't give them a good incentive to return to work, especially if the insurance carrier is investigating and they know that a check is still coming from you. You are not required to do this. There's no law in the state of Wisconsin that says you should do this. It used to be years ago school districts would do that. They no longer have that practice. So you're going to be paying out more than you would be receiving back. But a good question.
Rebecca asked, what do you recommend for an employee telling the employer that they have a pre-existing condition? Do you tell them they need a full release from the doctor or provide light work for them?
That is a very good question as well. When you hire someone or in the state of Wisconsin, when you hire someone, you hire them warts and all, which means if they have a pre-existing condition and under your employment, they aggravate, precipitate, or accelerate that condition on a temporary basis, you, the employer, will be responsible until they get back to their pre-injury status. So if you have someone new coming aboard and you find out this information, you may know it ahead of time, you may find out afterwards. Yes, the best thing you can do is make sure that they go to their treating practitioner who has treated them for this pre-existing condition or still is, and the doctor submits to you exactly, number one, do they have any permanent work restrictions? They may. And if they don't, that's even better. But I would get that in writing from the treating practitioner. Good question.
So we'll go ahead and have Peg continue with the webinar. There will be more time at the end for more questions, so please continue to type them in, and we will address them at the end. Thanks, everybody.
Great question. All right, let's walk through a claim together and put what we know or what we've talked about to task. Patty Jones, a long-term employee, is working at her job as a punch press operator. She has been well-trained and has worked for you for 12 years. She's a good employee, and she has been having difficulty with her machine but has not reported this to her supervisor. On July 11th of this year, she took it upon herself to alter a safety guard on the punch press and did not advise anyone. That same day, as she was doing her job, she had her hand in the machine and it came down and crushed her right hand. She is also right hand dominant. A coworker found her and called the supervisor immediately. So now we've prepared for this. What do? Immediately call 911. You'll want trained professionals treating her at the scene and in transportation to urgent care. So that's your first and utmost responsibility. Second, you want to call the family, make them aware of what happened, where she is being transported to, so that they are aware of the situation. Third, make sure no one disturbs the accident scene. Pictures have to be taken, measurements may have to be taken. The site should be as it is, and so you may want to be calling maintenance people. Perhaps another agency has arrived. The police were called. In many small towns, when the ambulance goes out, the police are called. They may want to do an investigation. Leave it as is until you've been given the okay from the insurance carrier that you're calling as well, before you disturb that accident scene. And next, you do want to call the carrier immediately. Don't report this via email or fax or snail mail. Talk to them and tell them what's been going on. Confirm with them that a nurse case manager will be assigned, and hopefully you know that day exactly where she is going to be taken. If she has to be med flighted to a bigger facility, make sure the company knows that as well. So you're on your way. Now, if you have a plant safety manager, he or she most likely would be in charge of the investigation along with the shift lead supervisor, unless this falls to your HR department. But you need to pre-plan as to who's going to lead that investigation. Now, what happens after this point is the insurance carrier needs to do their due diligence and do their job, and that's why you pay the big premium. What they're going to do initially is make a 3-point contact. They may be calling up a nurse, but their job within 24 hours that comes from their best practices is include making contact with you, whoever's going to lead the investigation, contacting the injured worker, if they're available to speak. If not, because they're medicated or in surgery, they're going to talk to the injured worker's family to at least say, hi, I'm so-and-so. I'm Sue Jones. I'm going to be doing this investigation. Here's the claim number. Here's my number. And I'm going to get together with your family, with the injured worker as soon as possible. And, of course, they're going to call the treating practitioner. Now, this is in a trauma center. Most times the trauma center surgeon or attendee is not going to be the person that takes care of this individual. So once that is known, who will be the lead physician, and there could be many, if it's a serious injury, who will take the lead in the injury. So we're going to investigate, we're going to cooperate, and prepare, and most times the insurance carrier will visit the accident site. We talked about that. It could be your claim rep, it could be an independent person, it could be a field rep for the insurance carrier. They want to photograph the machine. They want to talk to witnesses or supervisors to confirm what they did or did not see. And I want to talk a little bit about that. Many times in the past, we've had injured workers tell us that, well, I know that there were witnesses to this accident. I know it was Joe, Jim, and Jeff. Well, don't take that for granted. Make sure you talk to Joe, Jim, and Jeff. And if they say, no, we were nowhere during that area, we weren't even at work that day, or they tell you that they did not witness that, the insurance carrier will want to know that information. That's called a negative statement. They may take a statement from them that indicates, hey, I was at work on July 11th, but I didn't see anything. I was not a witness. I was not in that area. That is very important to know. Some of the things you should prepare for, and we've talked about this before now already, definitely a job description, definitely materials regarding the machine itself, and to include the manufacturer's name and address, the model and serial number, any maintenance records of the machine that you keep internally or that are kept by the manufacturer's rep on site, training materials and any documentation of Patty's training, items that she may have reviewed and signed. I took the punch press update class on March 9th of this year and understood the materials I was presented with. Any photographs that you took of the scene or co-workers took of the scene. Definitely the ambulance report. Once again, they do write a report, and that is very important. A police report if they are called, and make sure that Patty's direct supervisor is available to them when they arrive at the scene to talk to. So right now, Patty's healing process is going well. However, the injury will involve surgeries to repair tendons, ligaments, nerves, and bone injuries. Her recovery time is expected to be 6 months to a year. Right now, she's on several prescriptions due to pain and infection. It's not a good time to talk with her when she's on narcotics, but you will, the insurance company will want to speak to her, especially if you have already found out that she's altered the machine. So what will happen after the initial trauma care is taken care of? She'll be discharged back to the treating practitioner, and they will write a medical treatment plan or ask your insurance carrier to obtain a medical treatment plan from the treating practitioner so you know what exactly is going to happen to her in the future. And many carriers have pre-printed plans that they can send. It's just confirming what are the actual injuries, what type of surgery have they had, what will they require in the future, how long do you think they'll be off, what equipment will they need. A surgeon is able to do this because they've probably seen this type of injury before, and that is their job. So you'll kind of want to know how this is going to work. Will they need physical therapy? Will they need occupational therapy? When can we talk about return to work? And that information gives you kind of a timeline as to how much will be paid out in the future for benefits and for medical bills as well. So after a time when Patty is lucid and she's doing well, she does admit to altering the guard on the machine to make the job go at a faster pace. So she's come clean with you. Under Wisconsin Statute 102.58, an employee may receive decreased compensation if injury is caused by the failure of the employee to use safety devices that are provided in accordance with any statute, rule, or order of the department. The machine must be adequately maintained and the use is enforced by the employer. Remember that, the use is enforced by the employer. If the injury results from the employee's failure to obey any reasonable rule, the rule was enforced by the employer for the safety of the employee, and the employee had notice of the rule. Compensation will be reduced by 15% weekly, but may not exceed $15,000. So what the insurance carrier may do, once they've decided that the claim is compensable, they may withhold 15% of her weekly temporary total disability benefits until investigation is completed. And that may be either on your side or the Workers' Compensation Division. So if your employee handbook indicates immediate dismissal for an employee who tampers with the safety equipment, you can terminate her. However, workers' compensation benefits will continue until she is discharged from care. If your employee handbook requires disciplinary action if equipment is altered, it is imperative that you do enforce this disciplinary action as indicated in your employee handbook. This may be very, very tough. You know, Patty's been good employee. She's had a stellar work record and attendance and has done very well. She's one of the lead workers for you. However, if it's in your handbook, you need to employ that disciplinary action because she did go against the rule. And that is a delicate situation after she's been injured so badly, but she did it to herself. And she signed the employee handbook and knew that this was one of the rules. And that comes into play. Make sure when your people review an employee handbook that they sign a date that they reviewed this information with so-and-so, understood, and have them sign the date that they reviewed that information. Now with the 15% penalty, the Workers' Compensation Division is going to get involved, and they may require documentation to enforce decreased compensation. This may include, has this ever happened before, and did you sweep it under the table or did you take disciplinary actions? How did you respond to that prior situation? They want to get to know your culture. If this is strictly enforced, then usually what will happen is they will invoke that penalty. In my time being in the claims field, I have not seen this enforced too many times. And sometimes by the time it's decided, that person is already back to work. And hopefully your claim rep has been holding or setting aside that 15% money on their weekly indemnity. If they haven't, then they've paid the full benefits, and that ends right there. So, and then before Patty comes back to work, or before anybody else gets back on that machine involved, have your safety manager or plant manager contact your manufacturer's representative to look at the repairs that either you've made or that they have made to that piece of machinery. So communicating with Patty. Now you've prepared for this incident. Your expectations have been clearly stated, and Patty has acknowledged she has reviewed and read the information, and you have her signature that attests to that, and I'm talking about the employee handbook. You also have training records to prove that she was educated on the use of her machine and any updates that were made to the machine by the manufacturer. The nurse case manager or claims representative will give you timely updates on the medical treatment plan and progression. And when cleared by her practitioner, you want to get Patty back to the workplace. And I'm sure it'll be a temporary use of only one-handed work because of the severe injury to the right hand. It is best if you can offer her full-time work at a regular rate of pay. And this is where it gets kind of complicated, but you have to prepare for this moment. She's got a severe injury, but there's nothing wrong with her left hand, and she would like to get back to work, and you can save money by getting her back to work. But it has to be cleared by her physician, and you have to have something available there at your workplace. So then you talk with Patty's supervisor about returning to modified work. You yourself and the supervisor must remain neutral and monitor her temporary work duties. The work restrictions must be adhered to by you and Patty. Some places of business will have a log, and at the end of every shift, Patty and her immediate supervisor will confirm that Patty Jones has adhered to her restrictions today, Tuesday, July 29, 2016. It would certainly be very easy to be upset with Patty, but now is not the time to terminate her employment. Now that's kind of contradictory to what I said, but if you don't have something in your handbook about altering machinery and there hasn't been any internal rules broken, now is not the time to terminate her. You would want your human resource manager and corporate counsel available for assistance if you don't have this in place in your handbook. You would want to explain to the decision makers at your business that under Wisconsin Workers' Compensation Law 102353, that any employer who without reasonable cause refuses to rehire an employee who is injured in the course of employment where suitable employment is available within the employee's physical and mental limitations may be subject to pay the employee's wages lost during the period of such refusal or 1 year's wages. I'm talking about refusal to rehire. And once again, if this is not in your handbook where you call for immediate termination or but you have disciplinary action, you would not want to dismiss her employment. The refusal to rehire is an item that is not covered under your workers' compensation policy at all. This is an instance where you must retain your own defense counsel and pay for any penalties awarded to the injured worker out of your own pocket. And knowledge is power, and being prepared for this type of situation would certainly save you money and time. Is there any questions at this time?
We'll give you guys a minute to type in your questions, and I'll pull up the Sherman HRCI credits while you're doing that. Okay, well, if we don't have any questions at this time, you can go ahead and write down your Sherman HRCI credits. And Peggy, do you have anything you'd like to add?
Yes, please, if you have any questions after this webinar, I'd love to talk with you personally. My direct line is 608-252-9604. That's 608-252-9604. And at any time in the future, please give me a call if you have questions. I would love to chat with you and help you out the best I can. Our general office number is 608-257-3795. And Susan Storch or myself would love to talk with you and help you out in any situation as best we can. And I want to thank you for your attention this morning, and it's been great discussing this topic with you.